the County Court of Common Pleas is again in session. Honorable Christine Curchi presiding.
Thank you. You may be seated. Ma'am, if you'll remain standing for me, raise your right hand, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Go ahead and have a seat. And then I'll just ask that you keep your voice up and speak into the microphone, please. You may proceed.
Thank you very much, Your Honor. Ma'am, can you please state your full name and spell your last name for the record, please?
Glenda Gunn, G like George, U-N-N.
Ms. Gunn, can you tell the jury where you live?
I live at 710 Fulton Street in Akron.
Okay. And looking at State's Exhibit number 14 there next to you, do you see your residence on that map there?
I do.
Okay. And using this pointer here, you press this button. There's a red dot. Can you please point on State's Exhibit number 14 and show the jury where your house is? How long have you lived there?
Since 2007.
Where are you employed?
Actually, I'm retired, but I do work for my church.
What church is that?
Jerusalem Missionary Baptist Church in Akron, Ohio.
What do you do?
1225 Vernon Odom Boulevard.
Okay. What do you do for them?
I am the administrative assistant.
Okay. Now, Ms. Gunn, were you aware or are you aware of two fires that occurred in your neighborhood in April of 2016 and May of 2017?
Yes.
Regarding the first fire that occurred on April 18th of 2016, can you tell the jury how you were made aware of that fire?
My daughter came into my room screaming. My blinds was red, the house is on fire, and she ran down the steps with her cell phone, and I came behind her as fast as I could, and we got out there. She was dialing 911, but the front of the house was engulfed in flames.
Okay. And so did you initially think it was your house?
No, I knew it wasn't my house, but
Yeah.
she said that she heard something popping. I think it was the electrical, something on the electrical pole that woke her up. But she noticed that her blinds were red, and so she looked out, and that's when she saw the fire.
Where was that house located, if you could point to it on the map?
It was,
Okay. Right in that empty lot there. Did you know the man and woman who died in that fire?
I knew the man. I had met him before, but I did not know the woman.
Okay. And his name was Lindell Lewis, is that fair?
Yes.
Okay. And can you tell the jury what you would observe go on at that house prior to the fire? What kind of things would they do there?
Well, he had a lot of people that's, always on the porch. Some of them I know were homeless because I had seen them begging, with the signs at the expressway exit. I seen a couple of them do that, and one of the people that I had seen over there before came to our church, and our church helped her and bought her clothes and toiletries and stuff, and tried to help her to get straightened out.
Now I'd like to draw your attention to May 15th of 2017. Do you recall that time period?
Yeah, if you help me.
Yeah, that was the day of the second fire that occurred on your street.
Oh, okay, the second fire.
Okay. How did you become aware that that house was on fire or that fire occurred?
Again, my daughter came into my room, and it was at dawn, and she was saying, Mom, she said, I think we have a fire on our street. And I went over to the side of my bedroom window that faces in that direction, and I saw two fire trucks outside, and one guy that seemed to be spraying the house down, but I did not see it engulfed in flames or anything like that.
And where was that house? Could you just point to it? Okay. And that's on State's Exhibit 14. You're referencing that in that fire. So the fire department was already there when you first noticed it?
Yeah, so I said, well, I didn't see any ambulances out there or anything like that. I said, probably everybody is okay. And she went back into her room and I tried to go back to bed, but maybe about a half hour later, my phone started ringing. People were calling to ask me if I was okay.
Family members or friends and family?
One of my friends was all the way in California and she called me.
Oh, wow.
She has some kind of Akron feed. She's a homegrown girl.
Did you know any of the family members that lived there at that house?
Not really, no.
Okay. Do you know if they had any pets?
Yes.
Tell the jury about that.
They had a dog there that my dog kept breaking out of our enclosure in the backyard to go visit.
Did their dog get out a lot, or?
Their dog was always out. I was trying to keep my dog in. My yard is totally fenced in. So the little rascal figured out how to dig up under the fence. And as much as we tried to pin him into the yard, he would always find a way to dig himself out, and then you see him following the other dog up the street. So,
Ms. Gunn, did you know the defendant in this case, Stanley Ford?
yeah, I was acquainted with him.
Okay, and when did you first meet him?
Actually, Mr. Ford was always very friendly, so whenever he would be outside, if I'm going in or out of my house, he'd always throw his hand up or wave, you know, and I'd see him in the grocery store. He, you know, sometimes him with his family down at the Acme on East Avenue.
Would you speak with him regularly?
If I saw him, I would speak to him, yeah.
Okay.
Because I looked at him as just a family man, you know, trying to raise his family.
Sure. And Ms. Gunn, I'd like to draw your attention to a day in May of 2017. This is going to be after the second fire had occurred at 693 Fultz. Do you remember a time period where there was a bunch of commotion going on outside of your house?
It was after we found out that all the people had died in that fire. And I had gotten sick, actually. I was in my bed. I had a slight fever. I knew I did, and I just didn't feel good. But
What did you notice going on outside?
Well, I kept hearing helicopters roaring in the sky, which is not unusual. Usually, if you hear a helicopter, it's passing through on its way to one of the hospitals. But this day, the noise just kept going and going and going. So I got up and threw something on to go outside and see what was going on.
What did you see when you went outside?
Every news truck, that you know, all the local news, Channel 3, Channel 5, Channel 8, Channel 19, investigator cars, police cars, and all up and down Fulton Street had cars, and it looked like going down Hillcrest had cars, and a lot of people outside.
You see police officers?
Yes.
At some point, did you see the defendant, Stanley Ford?
Yes, I saw Stanley was standing at the end of my driveway when I came out of my house.
Can you point on your map where he was standing? Okay. Who was he standing there with?
A group of people. I assumed some of them may have been relatives, but I really didn't know any of them.
Did he say anything to you?
I said something to him.
What'd you say to him?
I said, "What's going on out here?"
What did he say?
He said something to the effect, they think I had something to do with this fire down the street. I don't know anything about those people.
Okay. And did he say anything about a camera being on his house?
Well, when he said that, I asked him, well, why do they think that? And he told me that they thought that because the neighbor had a camera on that saw him going into the house around 2:30 in the morning. He said, I can go in my house whenever I get ready. Something to that effect. And then I turned around and went back in my house.
He said the camera had observed him going in the house at 2:30 in the morning.
Around 2:30 in the morning, yeah.
Ms. Gunn, do you see the person in the courtroom who made that statement to you?
Yes.
Can you please point to him and describe what he's wearing for the record, please? You can point with your finger, you don't have to point with that.
He's got on this plaid blue shirt and a face mask.
Your Honor, may the record reflect that the witness is identified as defendant.
The record will so reflect.
Do you know Mr. Ford's sister?
No.
Okay. Was there someone there with Mr. Ford when he was making that statement to you?
Yeah, and I assumed it was a family member, maybe a sister.
Why did you assume that?
Because after he said that, she called him over to herself. As I was turning to walk away, she was calling him
Okay.
to come here.
Telling him to come over here.
Mm-hmm.
What did he say to that person?
I don't really recall if he said anything to her. I think that I do recall, though, that he did just go over there to her.
Okay. I don't have any other questions.
Thank you. Mr. Gordon.
Thank you, Judge. Good afternoon, ma'am.
Good afternoon.
My name is Joe Gorman, and this is Scott Riley, and together we represent Mr. Ford. I don't have many questions for you, but if you don't understand my question, just let me know and I'll rephrase it so you do. Is that fair?
Fair.
Is it Miss or Mrs. Gunn?
Miss.
Miss Gunn, that day that you spoke with Mr. Ford on at your driveway, that was after the fire, correct?
Yes.
Was that was the same day that they were actually searching Mr. Ford's house?
I don't know what they were doing with his house. I had heard about them searching, but I didn't pay attention to any of that until after he told me why they thought he did the fire.
Okay, so he was telling you he's telling you that they, meaning the police, thought he did it.
Yeah.
Okay, and this wasn't the morning right after the fire. This was the next day, probably.
I'm not sure.
Okay, you don't remember.
No.
Okay, but he's telling you what the police are accusing him of and why they're accusing him, correct?
Objection.
Hold on a second.
Overruled. You may answer.
Would you repeat the question?
Your understanding was he was telling you why the police were accusing him, correct?
Yes.
Okay.
When he said they think, I assumed he meant the police.
Say that again, ma'am?
When he said they think,
Okay.
I assumed he meant the police.
Okay. And do you know whether or not he had already talked to this man, Detective Looney, prior to making that statement to you?
No, I don't know.
Okay. Just 1 second, Judge. Ma'am, thank you for answering my questions. I don't have any more at the moment.
Mr. D'Angelo, you're almost done, ma'am.
Ms. Gunn, just a couple questions. You testified that the defendant said, they think I had something to do with the fire down the street.
Yes.
Okay. And then he later said, in response to your question, why do you think that? You asked him that,
I said,
correct?
why do they think that? Yeah.
And he responded, this guy over here has a camera on my house, right?
Yeah, he said his camera saw him going into his house
Good objection,
at
leading nature of the questions.
2:30 in the morning.
Hold on a second. Overruled, though. I noted, but overruled. Go ahead, finish your answer.
Go ahead.
Yeah, he was saying that the camera had captured him going into his house at 2:30 in the morning, which I really never saw that camera there before until he pointed it out to me.
And what did he say about going into his house then after that?
He could go in and out of his house, you know, whenever he wants to, or something to that effect.
I have no other questions.
Ma'am, but your understanding is he's telling you why the police are accusing him. The police are telling him they have him on camera, correct?
That's correct.
Well, yeah, as to the characterization, that's what you assumed he meant, is that correct?
Yes,
All
ma'am.
right.
No further questions.
All right, ma'am, you're done. You can step down, thank you. You can go right out this door, thank you so much.
You're welcome.
Do you have any other witnesses for today?
All right, ladies and gentlemen, we're finished a little early today. I have ordered at 3. So we're going to break for the day. I'm going to remind you the admonition I've given you at all breaks and at the end of each day. It's important that you be fair and attentive throughout this trial. Do not discuss this case amongst yourselves or with anyone else. This includes family, friends, and the media. You must not post or read anything about this case, whether on the internet or through any broadcast or media. That includes any laptop and or including your cell phones. Any such discussion, if discovered, could lead to a mistrial and again severely compromise the party's right to a fair trial. Do not permit anyone to discuss it with you in your presence and do not form or express an opinion on the case until it's finally been submitted to you. And so leave your notepads upside down on your chairs and then we will start tomorrow at 9 a.m. We're adjourned.
All rise, please.
I have executed an order to have Mr. Boggs transported from the reception center, and I believe that's at Orient, which is south of Columbus, is where they're telling me he's being housed at the moment. So the earliest that deputies can pick him up will be Wednesday morning, and Mr. Mason is working those details out with Mr. Pekarski. All right. So it appears that the state may have 2, possibly 3 witnesses, plus the 2 Ring Central for tomorrow. Is that right?
Yes.
All right. So there's a likelihood that you could be resting your case tomorrow?
Yes.
All right. I mean, it's fluid. I get that. I'm just for scheduling purposes. All right. So Wednesday, there's a good chance, I don't know, it's a 2-hour drive. So even if they leave at 7, they're not going to be back here till 9 and 11 in the morning. So I'm not sure if you have other witnesses, but I want to talk about these other witnesses because, I want to understand, based on the conversations that, you and Mr. LaPrinzi have been having somewhat on the breaks, and what you expect these witnesses to testify to. I want to have a record of that, and then we'll go from there. And then I'll make my decision. So I know that you have 2 deputies subpoenaed from Portage County, and I don't know what the nature of their testimony is going to be.
Judge, I guess proper what we anticipate. Oh, I'm sorry. You told. I can proper judge what I guess I anticipate the testimony to be. Why don't I start out by doing this, Judge?
Sure.
It's brief, but there is a report that's been provided through discovery from Corrections Officer Karen Kraus, Portage County Justice Center, who authored this, and I think it would give the court some insight into where we were going. So you already know, Judge, from the record or from opening statement from the prosecution, they stood up and they told the jury that Patrick Boggs was a suspect in the second fire on May 17th because he had started his wife, Angela Boggs, back years prior on fire because, and all the information that we're getting, judges, and all the police reports is because he's a racist. And he did not like the fact that she was dating a black man. So that's just the background of Mr. Boggs. He went to prison, I think, for 10 or 12 years for pouring or igniting her with lighter fluid and trying to burn her to death, I think. He went to prison for that. So that's throughout the discovery, Judge, we learn of him. He's listed as suspect number 2 in Detective Looney's ROI, his report of investigation. And with that said, Judge, what they did was, as you already heard, they went out, they arrested him on a, pursuant to, I believe, his parole, and put him in jail, put him in custody, brought him to the 6th floor and interviewed him. And of course, Judge, he denied any participation. They also subsequently did a search warrant, and he was in the Portage County Jail. If I'm not mistaken, Judge, it was because of some parole violation, but it was really because he was a suspect in this case. So while he's in the Portage County Jail on May 21st,
Of what year?
of 2017,
Okay.
after all that had happened, after he'd been interviewed, and actually the same day he had been interviewed, Judge. It says on May 21st, 2017, at roughly 14:35 hours, 2:35 in the afternoon, inmate Selby pressed his intercom and requested to speak with an officer. At this time, he would not state what he wanted, instead requesting to speak with me face to face. I entered CM1, which I'm assuming is a cell block, and tried speaking to him through the food pass of his cell door, but he was speaking so quietly that I simply couldn't hear him to understand his request. He motioned to cell 126 a couple of times, however, and I gather that it had something to do with inmate Patrick Boggs. I advised my CM pod officer, Don Tawney, to open cell 125 and instructed inmate Selby to follow me to the officer desk. He followed me, and when we reached the desk, I again asked him what was going on. It was at this time that he informed me that inmate Boggs had just confessed to him the murder of the family in Akron. He stated that inmate Boggs had told him he started the fire using barbecue grill on the porch of the house and made further comments of throwing hot coals into a plastic garbage bag. Inmate Selby appeared a little shaken and stated one of those kids was his, meaning Mr. Boggs' kid. I'm adding that, Judge. How can someone do that, question mark, unquote, unquote. He further stated that when inmate Boggs made these statements, he also stated that he did it out of anger over his ex-wife having a relationship with a black man. Having witnessed inmate Boggs sitting outside of inmate Selby's door for a little while throughout the day talking to him, so the deputy sees this conversation taking place, I immediately advised my shift supervisor, Corporal Karen Marlowe, of what inmate Selby had told me. She then contacted Assistant Jail Administrator Dan Burns to inform him of what had taken place. I spoke to him briefly on the phone, and he advised he would contact Akron PD himself. Corporal Marlowe then instructed me to write a brief report of what happened. So we have two of her and another Portage County deputy subpoenaed to come in to talk about their observations. When I say communications, I don't mean what he said, Judge, with inmate Selby. What they did in response, the fact that they contacted APD in response, I think is relevant to this case. And Mr. Selby saying, yes, I pressed the intercom button. Yes, I wanted to speak to them after I spoke with Mr. Boggs. Yes, I told them what Mr. Boggs said. None of that's hearsay. Is relevant and admissible to this case as a suspect in this case for Mr. Boggs. And then bringing Mr. Boggs in, Judge, to ask him whether or not he confessed and said these things to that inmate is something that we should be able to do.
Do you want to say anything?
Do I need to?
Do you want to respond for the record?
Well, for the record, Judge, I mean, well, the court's already made a ruling without needing me to do it. I don't want to waste anybody's time. So, obviously, Judge, that's hearsay. It's just, it's the appearance of trying to allude to something and let the jury have an impression, just like if I were to bring somebody in and have them take the Fifth Amendment in front of them to have them believe they're taking the Fifth because they had something inculpatory to say.
You know, like maybe the wife comes in, like, I know there's privilege, but you know what I'm saying, or a brother or somebody comes in to testify and say, you know, you're here because we subpoenaed you in regards to this case, and he takes the fifth as though he's protecting his brother. And it may not be for that purpose, and you can't do that. You have to do that outside the presence. There's a reason for that, is because it's trying to give an impression to the jury that is inadmissible and impermissible. And so we absolutely feel this is inappropriate. Just like if we were to say that somebody was talking to Stanley Ford and it looked suspicious, and we brought them in and said, deputies, did so-and-so talk to Mr. Ford, and did it look suspicious, and then did he immediately push a button and call APD? It would be, they wouldn't even get close to coming in and testifying in that case. And so we would object to any of that testimony, Judge.
There's a lot of circumstantial evidence involved in it, Judge. The relevance and the time frame in which this happens, the immediate time frame in which it happens, was Mr. Boggs talking to Mr. Selby right after he's been confronted by the police. We should be able to ask Mr. Boggs these questions, and we should be able to lay the foundation in front of the jury for why we think it's relevant to ask these questions through what the deputies did. It's in the police investigation, Judge. They chose, not our fault, but they chose not to go out and interview Mr. Selby. So all of that's relevant information. And we talk about circumstantial evidence. This is circumstantial.
Absolutely, that's absolutely not circumstantial evidence of anything. It just, we have people that talk to Mr. Ford all the time, and to put them on the stand to suggest that he's confessing to them is not.
How could we not be able to explore
You can with Mr. Boggs.
a suspect in this, through what?
Through Mr. Boggs.
Well, no, Mr. Boggs is most likely going to come in and take the fifth. So we should be able to tell the jury why we think he's a suspect. Not only what the Akron police chose to do with him, but what was also developed outside of what the Akron police chose to do with him. And the immediacy of what is happening makes it extremely relevant and probative in this case.
Immediacy of 4 years later?
No, the immediacy of him on the very same day he's being questioned, he's being sniffed by a drug or an arson dog, and the fact that his place is being searched, he's being questioned, and to come right over to the Portage County Jail and immediately confess, we should be able to ask him if it's true.
You can absolutely ask Mr. Boggs that question. But what will not happen in the order that you want to put it on is that the deputies aren't going to testify, and then you maybe put Mr. Selby on, and then maybe you put Mr. Boggs on. You have to get Mr. Boggs on the stand, and you have to ask him if he made these statements.
And if he denies?
And if he denies them, you can impeach him or ask him, if I were, I don't want to do your job for you because I know you know how to do it. But I'm going to limit it to is if I told you that Mr. Selby's prepared to come in and say you confessed to him, is he going to be telling the truth? And then whatever his answer is, you're stuck with it. You may not impeach him with extrinsic evidence.
I'm not trying to impeach him.
But if you try to bring in Mr. Selby to say he did say that, that's impeaching with extrinsic evidence.
I wasn't trying to do that.
And you cannot bring the deputies in to say, but Mr. Selby told me. Now, if you want to ask him, did you get a report from Portage County? Right?
Sure.
And did you investigate that report?
But Judge, with all due respect, I am not going to ask.
But you are implying that whatever he said to Selby, that Selby told to the deputies, is something so nefarious that it's got to go straight to whether or not he's a suspect. You have him on the stand. You get to ask him why he's no longer a suspect.
So Judge, if Mr. Boggs either takes the fifth or completely denies saying it, one of the two.
But I'm going to tell him he can't take the fifth because he's not a suspect,
No,
and
he can take the fifth.
well, he can, but then you can grant him immunity.
No. You can grant him immunity.
Well, sure.
But I can't, and I won't even ask for immunity. If he takes the fifth, just like if somebody takes the fifth in any other situation, they have to do it outside the presence of the jury. And if he takes the fifth, it ends right there. Now, I will tell you that they did investigate it, and the problem is he took a polygraph.
The problem is what?
He took a polygraph, and he passed. So we are really in a bind then, because now he's going to say, what?
Yeah.
We cleared him because he took a polygraph. See? And then that puts us in a bind, and it makes it really look...
Yeah, it gets to be a
Well, we're in a bind because Mr. Lindell's ex-wife refused to take a polygraph. We didn't talk about that either. And she had an attorney call to protect herself. So we didn't get to talk about that either. So that's not even relevant to this conversation because under Ohio law, that polygraph doesn't mean anything evidentiary-wise.
I understand that.
Okay, but again,
to
why are
answer
you
this
two
question-
talking to each other?
Because we work things out sometimes.
My
It's not
point
gonna happen
is,
this time.
his statement to whomever, Mr. Selby, is hearsay. It's hearsay. It's an out-of-court statement, asserted to prove the truth of the matter. Whether or not you plan on asking it, whether or not you plan on implying that it was said, it is hearsay. It's not coming in. If Mr. Boggs takes the stand, you can question him about what he said, to whom he said it to. If he denies it, then what I can tell you is you could bring the deputy in to say, I saw Mr. Boggs and Mr. Selby talking shortly thereafter around his cell.
That's what I wanted to do.
Other than that, nothing else.
And-
Not about a report, not about a report turning it over to them, none of it, because that's the hearsay. Her observations, completely different, because you're not impeaching him with any statements. You're showing what she viewed or what she witnessed.
Well, she also received a intercom call, a buzz from the inmate who wanted to speak to her. He appeared very nervous, and he was pointing towards Mr. Selby's...
Mr. Boggs.
I'm sorry, I apologize, Judge, thank you. Mr. Boggs' cell. So she took him out, and she had a conversation with him. I wasn't going to ask her what he said in that conversation.
I know that.
Yeah.
I know you're not going to ask him that.
But that's all relevant.
It may be relevant, but the prejudicial value of that clearly outweighs the relevancy of it because you're implying things without having the testimony already there.
And the problem is, Judge, they can't have it both ways. See, they want to say it's not admissible for me to ask Mr. Selby what he said. I get it, but they can't have it both ways. They can't shut us down both ways. If we're happy to
First
have
of all,
Mr.
no
Selby.
one's shutting you down. I'm ruling on the admissibility of evidence.
I know, but-
And so this is how I'm ruling preliminarily.
All right.
It all depends, in my opinion, what Mr. Boggs does when he takes the stand. But I want you to be clear. It's not going to be the deputies, Mr. Selby, and then Mr. Boggs. If you're going to call him, it's got to be Mr. Boggs first before any of those other people testify about what transpired in that jail. And then I'll revisit all of your other concerns and questions. And it
Okay.
really does depend on what Mr. Boggs does when he takes the stand.
Okay.
But in the meantime, we are going to have to find out before the jury comes in what his intentions are. And secondly, I'm going to then instruct him that if he does choose to testify, he cannot say or testify that he took a polygraph.
All right. And for the record, Judge, and I didn't have the name at the top of my head, it was Francine Lewis who was asked to take a polygraph, said she would, refused to show up, and had her attorney call and say she's not taking the polygraph. So I say...
Is she alive?
Yeah.
Why aren't you subpoenaing her in? Bring her in and ask her, did she kill her ex-husband?
Oh, Judge, Judge, there's trial
I
strategy.
understand there's trial strategies, but in the beginning, we went to sidebar and agreed that some of those things were being redacted because they were talking
Yes.
about polygraphs for everybody.
I know, he brought it up this afternoon.
I know, but what he's saying is, Sergeant, no, I want to make sure it's Lieutenant? Oh, Detective. Detective Looney, then, when you cross him and he looks like he didn't do his job because he ruled him out, he's not going to be able to say I ruled him out because he passed a polygraph.
Well, he ruled him out for inadmissible evidence.
Well, that's exactly what we're asking you to do, the court to do here. And the judge.
I understand, and I ruled.
I know you have.
Somebody can pass a polygraph and still be lying. That's why it's not admissible in our bylaws, but it's stipulated.
No question. Somebody can deny doing something.
But the police can rely on that as an investigative tool, so let's be clear about that.
And Judge, with all
And they
fairness,
have.
they can also rely on an investigative tool when, and we would have loved to have this cross-examination technique with the detectives. When sometimes when detectives ask people to take polygraphs, they do it as an investigative technique, and then they become more of a suspect when they refuse to take the polygraph. And we would have loved to have gone down that road too, but we weren't able.
Well, Stanley refused too, so, I mean, that would open all kinds of doors. So,
Right,
but
which
here's
is
the
why
only-
none of that's coming
Right,
in.
and we've agreed to that, because it's the rule of evidence. One last thing you had mentioned, and I just want to respond to it because that came up and I have not said anything about this. You said that in your mind, the way and you'll revisit it, but I want to put it in the court's mind so that if it comes, you can think about it legally and evidentiarily wise. That if Mr. Boggs comes in and says, I didn't tell him that. You have indicated that you're going to allow the deputy to come in and talk about them, seeing them talk to one another. That's not impeachment of what he told him or didn't tell him. It's only impeachment that they had a conversation.
Right.
If he says, I didn't have a conversation with them, I would agree, but otherwise, if he says, I've talked to him many times, not about that, I've never confessed to him, our position is, and we would ask the court to rule, that that does not impeach him.
Well, the fact that he had a conversation with Mr. Selby would go to this jury's assessment whether they want to believe some, all, or none of what Mr. Boggs responds.
Right.
I know, so.
I mean, it may go to
Impeachment is not evidence, though.
it may go to an issue other than the actual conversation. It may just go to, listen, it's a fluid scenario. And as again, we're only going to address this after Mr. Boggs testifies.
Fair enough, Judge.
Because if he could say, yeah, I talked to him a whole bunch of times. And you know what? Never mind. I'll keep the rest of it to myself.
We do want to play the walking videos tomorrow. I don't know if you wanted to view them or what you wanted to do.
Sure.
Judge, and then as it relates to that, Judge, I also had a thought after we had our discussion this
Just
morning.
a thought.
A thought on that specific issue. Apparently, the prosecutor then told the court that they did in fact engage an expert who was told them that they didn't have enough information to make an opinion. Obviously, we've never received that, name of that expert or any opinions that he may or may not have done, or even a letter saying he looked at it and didn't have enough information. I think we're entitled to that. If they have an expert.
Is there something in writing somewhere?
We consulted an expert to say, hey, can you even do it? And he said there's not enough stuff here to even make an analysis. He sent it all.
Oops.
And they don't have a right to that. There's nothing exculpatory.
And I don't think we're asking anyone's opinion.
No, let me see these videos.
There's 3 of them now.
There's 3, whatever it was.
What?
ODRC is also going to need a subpoena from Mr. Boggs to go along with the paperwork.
Okay. So did you get one printed?
He was subpoenaed.
Okay, is that on?
Well, it went to Portage County.
They handed it to him or not.
It's
Well,
filed,
issue a
it's
court,
filed, I can pull it
don't
off
look at
the-
them, just, it could issue a court subpoena and have him brought here, under my subpoena.
Yes, it's.
Yeah, just, right. Just get a subpoena issued, and,
You gonna play those now?
Yeah, she wants to see it.
I can shut off the other monitors if you want, and I can just, it'll just show up on mine.
That would probably be better.
Yeah, there you go. Okay, go ahead.
So is this the one that's marked? Give us numbers.
137. Stacy's at 137.
That's dated, so that first video was April 12th, 5 days before the 2016 fire.
5 or 6.
It's 5 or 6.
I show 412, yeah.
So is that the one that he referred to having? No.
Next, I'm going to play Stacy's at 134.
What was the last one?
Thank you.
137.
Oh, this is channel 4. I'm confused.
This is from 719.
Right, I know, but I think why do I feel like I just saw this 6:30-36 a.m.?
You did.
Okay,
You'll see something.
okay, I appreciate that.
And am I fair in saying that that's the one that he referred to as having 2 unknowns?
Don't know, you'd have to ask him.
Yes, I think it is. I'll go back and look at mine.
Excuse me.
And then the last one I'm going to play, Judge, is State's Exhibit 139.
And I'm presuming the person in the blue shirt and the jeans is Mr. Ford, even though his face is.
Yeah, and that will be testified to by Detective Looney.
Okay.
I think that, Judge, and I think that is when they brought him into the cruiser on the 18th of May for an interview. Is that right?
Yes. That's all of them.
Mr. Riley? So my question is, you're planning on presenting this through Detective Looney?
Yeah, he'll testify about the known video of Mr. Ford walking to the vehicle, and then we'll play these without any opinion.
Invites for speculation, Judge. There's no foundation, there's no, I just think it is error to allow the jury to guess as to what they're seeing.
So we know the one video is Mr. Ford walking to the cruiser on the 18th of May for an interview. Do we have confirmation from some source that the other videos in any way that somebody can say that is Mr. Ford?
They don't, and then the one with the two unknowns, they're trying to tie in those unknowns.
Right. Yeah, they are. I mean,
Based
clearly,
on-
I don't think that's like undisputed that they're not trying to do that. So again, the instructions are that the jury can determine from the facts and the evidence whether or not that is or is not Mr. Ford. I mean, they can determine what credibility and what amount of credence they want to give to that bit of testimony or that bit of video. I get it, but I find that the probative value outweighs the prejudicial effect, and I'm going to allow them to play that with Detective Looney's testimony over the defense's objection. And again, you can renew it before Detective Looney takes a stand tomorrow. All right, well, any other hot button issues? I know you guys want some time to speak with Mr. Ford,
Yes,
right? Okay, so we can do one of two things. Is everyone out of the jury room? Did you clean it? So, deputies, can you take him back there so he can have a conversation with his attorneys, and then we'll see everybody in the morning. I will have a draft of the jury instructions tomorrow.
And this is off the record, this is so,